Court. Brian Thomas is joining us live for more on this story. Brian, has the hearing resumed? What is on in the court currently?
Well, Uday, definitely as of now the hearing has started and we have the details with us. Definitely, the SG Mehta has clearly stated about and it has started from where it left off yesterday. And definitely it has started that SG Mehta has started saying that the Lordship is going to stay on a statutory provision by itself, by its rare. And even the CJI even has said that it's just a minute. And the latest also said by the SJ that he is respectfully rather arguing the fact that the questions are very pertinent and also it is difficultly putting and he's putting it in a very candid manner that there are no issues as considering on the prima facie that has been going regarding on some provisions and also said that to consider the history and as government are even answerable also to people villages and people are taken by the as rock. It is considered a piece of legislation. Petitions were also rather very importantly filed before the assent as well. Very importantly, there have been a lot of multiple, back and forth going on where G. Kumar has also said that they are not deciding the matter as of now, where the SG has clearly stated that the Lordship rather is taking a very hard step and he is also saying to allow him to place within a week his preliminary reply also the documents to show how he came into the picture, how this entire thing had come into the picture. And also very importantly, the Chief Justice of India clearly stated that they had a particular situation where indemnities are there. They have said that there are certain positive things and also said that somebody has asked of a complete stay and even the CJI said that they have not said anything regarding that. And also they said that they don't want the situation to change. There are provisions such as the 5 years age practice of Islam, and they're saying that, and there is a thumb rule on that. So clearly stated that the 5 year rule practice of Islam, and this is definitely a thumb rule on that also, and said that normally the situation prevailing today should continue to not upset the rights of the parties also clearly. So right now, yes, these are the back and forth going on. It has left from where it started, but till now, what we're getting to know that the CGI has also intervened and said about the 5 year thumb rule also that clearly the Islam has it and one should prevail and not continue to upset the rights of the parties. So that.
Talk about yesterday. Well, yesterday also, of course, was the day the hearings, of course, began. Brian, yesterday was the first day of hearing in this particular case. The appeals, of course, were formally heard. Kapil Sibal, Abhishek Singhvi amongst those who made arguments for the appellants. There were some pertinent observations as well from the CJI and others on the bench. Take us through what transpired yesterday. Which were those most important observations, Brian?
Well, definitely. Talking about yesterday, there were 10 petitions that was taken yesterday, including those that was filed by, Azharuddin Owaisi also, Amanatullah Khan, Manoj Kumar Jha, and several other religious and civil rights, organizations. Very importantly, to summarize the entire thing that happened yesterday and for our viewers also, there were three key concerns that was
absolutely. Brian, stay with us. In fact, before we come across to some of those more important observations from yesterday, let's just talk about what's happening currently in court. The Solicitor General has sought 1 week time for detailed reply. The SG has said, Your Lordship is taking a harsh step. We'll show with documents as well. They've sought obviously more time from the Apex Court. The Chief Justice of India said, Mr. Mehta, we had a particular situation where infirmities were there. We said there are certain positive things. Let me say, somebody asked of complete stay. We didn't say anything today. We don't want the situation to change. There are provisions such as 5 years practice of Islam. We are not saying that. There is another thumb rule. Normally, the situation prevailing today should continue to not upset the rights of parties. The Solicitor General, of course, replying to that by saying, if your Lordship we say something about Waqf by user, it will have consequences. So a brief exchange there between the Solicitor General and the Chief Justice of India, Brian, in court.
Well, clearly, even just before this, I even stated the fact that yes, the SG has clearly stated the Lordship, they want to say something about the work by users. It will have severe consequences. Now, even to the fact that CGI has clearly replied, and there's a proper back and forth going on there, let me tell you that. The CGI has also intervened and said that the appointment of boards and councils working views are already declared as registered in terms of S36 of 1995 and not in terms of the 2025 Act. and says that they don't want the position to change in Parliament, makes laws, executive decides, and judiciary. To which Trivedi has intervened, saying, but the Parliament too is clearly entitled to. So that again, the CJI has intervened. So, there's a proper conversation going on so that even so that CJI has intervened and said, okay, but fine, but no appointments to the boards and councils no need to register work. So that even Kumar has said that what is being said today, here and no work will be without registration, and penalties were imposed in 1923 and 1924. And to the fact, even SG has clearly stated that the reading of provision is nothing can happen within a week, even if the government, wishes to speak on that as well. And just back, earlier also it was stated, G. Kumar was saying that it was not deciding the matter, we are not deciding the matter. So that fact, SG has said that the Lordship is taking a very hard step, a very difficult step rather, and he also says that he wants a week now.
Absolutely. Basically, of course, obviously the Solicitor General does not want the, the act to be stayed right now at this preliminary stage of the hearing very clearly. Okay, more news coming in now. The Chief Justice of India has gone on and said, I will dictate the order. The advocate for Chhattisgarh, though, has come in now saying, hear me for a minute. We are supporting the legislation. The Chief Justice of India says, I'm sure there are Hindus opposing the legislation too. So that's a big statement being made there by the Chief Justice of India, of course, while responding to the advocate representing the state of Chhattisgarh, saying that perhaps there are some Hindus who are opposing the legislation as well. Obviously, this is in reply to the advocate for Chhattisgarh who had said, we support the legislation, Brian. In fact, the CJI also saying, let me dictate the order. So it could be an interim order today as well that we could hear from the Supreme Court.
Well, clearly, clearly, CBI has now come into place and said that he will dictate the very order. And the advocate for Chhattisgarh also said that to hear him for a minute, we are supporting the legislation. And then the CGI has said, yes, he's sure that there are, but Hindus are opposing this legislation. And to the fact, even, SG has said that he will make a statement if any state, not before the court, but if he makes an appointment, it will be void. And CJI has said even the work by user, if it's registered under these as the 36 and of the 1995, similarly to that fact said that 3C proviso has also that they will not treat it as work. So that even the CJI has clearly stated that once they claim it is worked, declared or registered, to that Sunni again said that is the problem. Work by users may not be registered itself. And then the CJI has said yes to that. We will dictate the order. And then, the advocate for Chhattisgarh has clearly stated that, hear him for a second and they are supporting the legislation. And CJI again to the fact replied saying that yes, he's sure that there is. But yes, Hindus are opposing.
All right, in fact, the interim order has come in now. The interim order has come in. The Chief Justice of India has begun dictating that interim order in the courtroom. It says, during course of hearing, the Solicitor General has stated that the union would like to put a response within 7 days. He further said he assures the court no appointments will be made to the council and board under section 9 and 14 till the next state of hearing. Waqf, including Waqf by user already registered or declared by way of notification, shall neither be denotified or the collector will change. We take the statement on record. So on that assurance, of course, of the Solicitor General, obviously there is no sort of interim stay put yet, but they are taking the point put forth, the assurance given by the Solicitor General on record in this interim order, Brian.
Well, clearly, again, I'll start off where you just left off and where I just left off. Clearly, this CBI clearly stated in the end that he is sure that there are and Hindus are opposing this legislation. And now, as for breaking also, that you have clearly mentioned, that definitely interim order. Now, during this very case of hearing, the SG clearly stated that the union would like to now put a response within 7 days of this. That even was said by the SG just a while back when we were talking. Now, he also further elaborated and said that he assures that the court no opponent will be made to the council and board under the S.9 and 14. And till that very moment also, till the next date of the hearing, Waqf will, including Waqf by user, already who are maybe already registered or who have already put a name on it, or are even declared by way of notification, shall neither be denotified, or the collector will clearly change, or have a different altogether meaning. But they take this very statement on record. So definitely a big statement saying that they have taken this very statement on record itself. And now clearly also there, so the CJI has said, as far as writ petitions are concerned, they only want 5 writ petitions, and it is impossible to deal with 100 or 120, and others will be, treated as disposed of. And then the CJI also continues to say that they are not going to refer the names.
In fact, the Chief Justice of India goes on and says, as far as writ petitions are concerned, we only want 5 writ petitions. It is impossible to deal with 100 or 120. Others will be treated as disposed of. Chief Justice of India also says we're not going to refer the names of the parties. We will refer to it as Waqf Amendment Act as name of the matter. So another important order, of course, given by the Chief Justice of India in terms of the number of petitions pending on the same issue before it, Brad.
Well, clearly, like I even mentioned, yes, clearly the CPA has said as far as the writ petition, they, 5 is still okay, but he clearly says that it is impossible to deal with 100 or 120 petitions, and they will be, these others, the remaining ones, will be treated as disposals of. Now, very importantly, he even said that we are not going to refer the names of the party, but he will be referring it as Waqf Amendment Act as name of the matter. And then the CJI has also said to appoint nodal counsels, very importantly to appoint nodal counsels. And so the Sibbal also said that, my lord, must say declared or registered, including Waqf by users also, so that even Sibbal has made a counter. And then CJI has said it includes Waqf by user itself. Uday.
Absolutely. In fact, of course, this is a big statement being made by the Chief Justice of India so far. They're also, of course, asking the centre to appoint a nodal counsel now as well, Brian, reportedly. In fact, we're also learning that registered Waqf by users is not to be denotified currently. So again, another, interim statement, of course, another part of the interim order by the Apex Court. They're saying registered Waqf by user is not to be denotified currently.
Well, clearly, that it has been said, yes, CBI has said to appoint nodal counsels. Sibbal says that it might not stay declared or registered, including Waqf by users. And then the CBI has clearly stated that, yes, it is agreed by the Council for Petitions that they will identify 5 petitions and lead, and others would be treated as applications. As even earlier you mentioned that 100, 120 petitions is impossible for someone to assess it. But yes, they will identify 5 of these petitions as lead, and others would be treated as applications itself. Yes, Kuda.
Absolutely. So, of course, a big statement being made by the Apex Court. Currently, no, change of status for a week at least because of course, this assurance by the Solicitor General. Also, of course, the Supreme Court saying that the other petitions stand disposed of. Only 5 writ petitioners are to be in court from the next hearing. Obviously, this has been done, Brian, because the courtroom is also extremely crowded. There are so many appellants in this case. All of them have lawyers, which is why the courtroom has been overcrowded since yesterday. Now the Supreme Court today saying only 5 writ petitioners are to be in court from the next hearing.
Oh, well, Uday, definitely, it has become a bombarding of issue. And it is clearly very frustrating also to overcrowd the court. And to that, even very importantly, the CBI has completely said 5 would be the 5 writ petitions would be considered as lead, because 100, 120 writ petitions to study them, to assess them, would be treated as disposal, because it is really important to deal with something of that sort. And also, very importantly, CJI has also said that to appoint nodal counsels, and also now clearly it has been said that now the 5 counsels, 5 writ petitions would be considered as least, agreed, and even CJI has said that it petitions challenging the very 1995 Waqf Act and the amendment in 2013 shall also be separately shown in the council, and it will be a file. It will be to file a reply itself. Uday. Yes.
Absolutely. In fact, the Chief Justice of India now going ahead and saying the writ petitions challenging the 95 Waqf Act and amendment in 2013 shall be separately shown in the cause list. It will be open to file a reply. So again, another important statement. It will be open to file a reply, and of course, these two petitions should be shown separately in the cause list of the Supreme Court, Brad.
Definitely, Uday. Also, I like to start off where you ended. So after that, the CBI has even said that it is liberty to grant it to grant to petitioners as a special case itself, challenging the 2013 Act to file a response, and even union and states may even file response, which they can, including Waqf boards also within 7 days, which is a 1 week period also. Now the CBI has also said that both sides will appoint nodal counsels, which becomes very important and critical at this point of time. Uday.
Yes. Now, of course, the Solicitor General has given an assurance that we will file a reply within 7 days, a short reply within 7 days. So the Supreme Court, of course, saying let the reply be filed within 7 days, and a reply to that be filed within 5 days of the service. Does that mean that we're getting a sense that perhaps the next hearing, after today's hearing concludes, will be, after, say, about 2 weeks' time? Is that the sense we're getting, Brian?
Yes. Yes. Because the SC said that let the reply be after 7 days. So yes, we are hoping that it would be after 2 weeks of the time that they would be taken. Because when CJ has said that it has the liberty to grant the petitions as a special case that challenges the 2013 Act to file response, and union and states may also file response, which includes your work board as well. And then also very importantly, and said that the time should be taken for 1 week also, that the SGS requested the CJ as well. But definitely the CJ has said that both the sides, very importantly, will have to appoint nodal counsels as well. Uday.
Yes, so let me in fact get a quick reaction. We are getting more news coming in. Brian, stay with us. In fact, the Chief Justice of India also going ahead and saying liberty is granted to petitioners as special case challenging the 2013 Act to file response, and union and states may file response, including Waqf boards, within 7 days. Both sides will appoint nodal counsel. So nodal counsel should be appointed by both sides is what the Supreme Court has said. Meanwhile, of course, they've given time to the sides to file replies which they wanted.
Well, definitely again, Uday, we've ended at so the fact when CGI has said that yes, both sides will appoint nodal counsels. Again, post that there was another reply by the CGI also that said that they clarify that the next hearing will be for the preliminary objections and directions for the interim order. So this comes big, yeah, and will be read as the Waqf Amendment Act, that is 1, 4 and 5 itself. Uday. Yes.
Sumit Peer, political commentator, also with us. Sumit Peer, no stay currently on the Waqf Act by the Supreme Court. However, they have said that there should be no change in status, as the Solicitor General has, of course, assured them till the next hearing. Also, interestingly, the Supreme Court deciding to pick 5 lead petitioners right now to prevent overcrowding of petitions and overcrowding of the courtroom. Sumit.
Uday, thank you for having me on your show. It's a very welcome decision because look, everybody has a right to go to the courts and which they have gone. But unfortunately, what we were seeing, there were people who were queuing up, trying to get that TRP कि भाई मैंने भी application लगा दिया. So that is now throttled down. That is now put to rest because only 5 applications will be entertained. Because what is the big motive? The big motive is to make it a bigger issue. You might have 1,000 people, 5,000 people, 10,000 people even, as per a sinister plan to go and file those cases so that it becomes beyond the capability of the Honorable Supreme Court to handle it. So I welcome this decision wherein the Honorable Chief Justice says only 5. Baki sab kharij. I mean, if he doesn't do it, tomorrow you will have, today you have 120. It's a matter of 6 months, 3 months, you will have 1,000 of them. And then everybody will become a hero, say, maine bhi bhai application laga di waqf ke against. So there will be a perpetual race of filing these applications which has been put to rest. Second thing is that, which is very important, the Muslim side wanted that there should be a unilateral stay granted to it, that everything stays, nothing has to be implemented. But what the Honorable Court has done, they said, okay, for 7 days, there'll be no major changes done, but they have refused to state, they have refused to, quash the decision, they have refused to overturn the decision. Say, okay, after 7 days, come with your replies, let's look at the replies, then we'll talk about it. Third thing is that all the cases will not be as per person, because people like Mr. Owaisi want to be the, heroes of the game. So now, unfortunately, it will be just 5 cases which will be picked up. I don't know what is the criteria of picking up these cases. When the cases are picked up, these people will, that will be Waqf Amendment Act cases or, cases against it. That will be the notion. The cases will be taken on the merit of it, and the argument will be done on the merit of the case rather than the individual fighting the case. And another thing is that, you had a lot of people who were trying to say that it has to be immediately quashed. It will immediately result in the disruption of Waqf properties, and thousands of crores of properties will be siphoned by the government in a matter of days. I think that all things have been put to the rest, though there was an argument which was tried to put in, and which remains a fact, unfortunately, that around 200 plus Hindu MPs also voted against the bill. But it's not a question of Hindu or Muslim, Uday, but whatever bill is passed in the parliament is the law. You can't say that how many Hindus voted, how many Muslims voted, that's not the question. And whatever the parliament passes, the bill, it might not suit the taste buds of Mr. Owaisi or Mr. Imran, whatever his name is, Hattan Gadi or whatever his name is, and some other gentleman. That doesn't mean that India will be driven by their whims and fancies. India will be driven by the rule of law. And for these all people who thought they will have a bumper Thursday opening and, it will get a stay, will get quashed, overturned, well, bad luck to them, and only 5 cases will be entertained. That means all the individual TRP and the tamasha they were trying to create, all the individual brownie points they were trying to make, that is not going to happen. So overall, it's a good step. And let's see in 7 days or 15 days when the next hearing comes, how does it go? But what I can get the feel of it is that Supreme Court is not in a hurry. Supreme Court is not ready to quash it. Supreme Court did not stay it. Supreme Court did not overturn it. And the 7 days leeway is given as per the request of the Solicitor General, where he requested in a way for 7 days, nothing is going to change, which is fair enough, which is good enough. And on the contrary, even the people from the Waqf boards and all, they were also supposed to give their replies, and the petitioners who filed the cases, they're also supposed to file their papers and all. So the climax of the drama, which was planned, that a stay, a win, and going on the streets and saying we have won, and the Modi is put in docks and the Modi government could not do it.
Okay, that hasn't happened yet. Manasvi Thapar, political analyst with us. Manasvi, Sumit Peer says that no chance given for political grandstanding by the apex court as yet to the political parties and the petitioners, some of them who are MPs as well. Obviously, the Supreme Court will pick 5 lead petitions now, they've said, because there have been too many of them, which is overcrowding the judicial process and also, of course, the courtroom. How do you react to how today's hearing has panned out and this status quo for now, which will exist for the next week or so?
Petitioners, and I think it's a very welcome step by the Supreme Court, which I bow down specifically, is that only 5 petitions are to be considered and nodal officer counsels are to be appointed from both the sides. I think it's a very
पार्लियामेंट के कानून को आप इस तरह से स्टे नहीं कर सकते हैं, और माननीय सर्वोच्च न्यायालय ने सॉलिसिटर जनरल ऑफ इंडिया के बात को माना है और उन्होंने संशोधन को स्टे नहीं किया है। सिर्फ उन्होंने उनके 2 पॉइंट पे सॉलिसिटर जनरल के बात को रिकॉर्ड पे लेकर के और अगली तारीख 5 मई मुकर्रर कर दिया है और 5 मई से इस मामले की सुनवाई शुरू हो जाएगी।
सर, यथास्थिति की बात कही गई, यथास्थिति को कैसे लिया जाए?
नहीं, यथास्थिति मैंने आपको बताया कि 2 मुद्दों पर, कि जो काउंसिल में और बोर्ड में अपॉइंटमेंट का जो मामला है वो अगली तारीख तक जो स्टेटमेंट सॉलिसिटर जनरल ने दिया है कि कोई अपॉइंटमेंट नहीं होगा, और दूसरा जो है वक्फ व यूजर, तो माननीय सर्वोच्च न्यायालय ने अपने आदेश में लिखा है कि जो रजिस्टर्ड हैं और गैजेटेड हैं उसको गवर्नमेंट डी नोटिफाई नहीं करेगी अगले आदेश तक।
सर, आप कौन से क्लियर है सर, वक्फ बाय यूजर को डी नोटिफाई नहीं करेगी ना? मतलब
नहीं, वक्फ बाय नहीं, सिर्फ वही जो रजिस्टर्ड एंड गैजेटेड हैं।
सर, ये कोर्ट में
हाँ बिल्कुल, ये ऑर्डर शीट में है। जो रजिस्टर्ड नहीं है, जो गैजेटेड नहीं है, उसको सरकार संशोधन कानून के हिसाब से डी नोटिफाई कर सकती है।
सर, आप किसके लिए अपीयर हुए थे?
मैं हिंदू सेना और हिंदू महासभा, 2 हमारे एप्लीकेंट्स हैं, उनकी तरफ से मैं संशोधन के समर्थन में हाजिर हुआ।
नाम बता दीजिए।
वरुण कुमार सिन्हा, विष्णु गुप्ता के लिए, और एक पवन अग्रवाल है उनके लिए, सतीश अग्रवाल। नहीं, आज की सुनवाई पूरी हो गई, अगली तारीख 5 मई की मुकर्रर हुई है। धन्यवाद।
आप सुन रहे थे आपकी केस
All right. In fact, this were the reactions, of course, pouring in from court. You can see there. Just look at that. That's the scene outside court number 1. The sheer number of advocates shows you how many petitioners there are right now. Obviously, how much interest also there is in this case. But which is why the Supreme Court obviously has passed that order today, saying that let there just be 5 writ petitioners and their lawyers in the next hearing. A pretty practical order, would you say, Ashwini Dubey? AOR Supreme Court, if I can draw you in here. How do you react to the way the hearing went today and the interim order passed by the CJI today?
Thank you, Uday, for having me here. Uday, it's when a constitutionality of any act is challenged and there are very heavy petitioners.
Okay, we're also getting word now that the next date of the hearing will be the 5th of May. So that's what I just, had put out a short while back, that about 2 weeks' time will be given. And that's exactly what seems to have happened. 5th of May will be when the hearing now will take place. So, over 2 weeks, of course, given to the petitioners to have their time to file their reply, and then of course also the prosecution to file their reply as well to what the petitioners have said. Yes, go ahead, Ashwin.
There are when there are heavy petitioners and heavy legal people with legal acumen appears before the court, they always raise some new points which needs to be heard. But it is very clear that the court has not passed any order which would be detrimental to the amendment of the Parliament. Supreme Court has to hear the matter on May 5th onwards, as you rightly pointed out, and the centre has been directed to file its response because ultimately stakeholder is the centre, the Union of India, because the law has been passed by the centre, by the Parliament and majority. Number 2, the Honorable Supreme Court has said that the no Waqf by user properties will be notified until the next date of hearing, means the May 5th, or if hearing starts, it may go because the constitutionality has been challenged. The Honorable Supreme Court, being the custodian of the Constitution, has always a legitimate expectation from the Parliament to see that whether there is any arbitrariness in the law amendment passed by the Parliament, or it is in consonance with the Constitution. That litmus test has to be checked. Third, the Supreme Court has said that no appointment will be made to the Central Waqf Council or State Waqf Council until the next date of hearing. 3-4 days back, the act has been, the amendment has been notified with the President of India. So in any case, it would have taken time. So there is nothing. Nobody was going to be, take a new position here. So that's another aspect. And the Honorable Supreme Court said situation on the ground might change if certain provisions of the law are not stayed. Now, another yesterday's observation, Uday bhai, if you see, the Honorable Supreme Court was also worried about the violence. Now, there are 2 important, crucial points I would like to discuss. And my brother Manashwit Hoffer, of course, is against the amendment of the I presume that amendment passed by the majority of the Parliament. 1, there are 3 types of court exist in the country, as I have rightly said: the Supreme Court, the High Court, and the civil courts. The Constitution specifically says union judiciary, state judiciary, and subordinate courts. And any property dispute, Uday bhai, correct me if I am wrong, I would stand correct myself. Any property dispute, be it of the religious mutt, be it the Religious Endowment Act, be it the land illegally acquired by any mutt or the mandir, will be dealt by the court of law. But here it was a unique case in the country itself where koi adalat nahi, koi dalil nahi, board or tribunal ka decision final hoga. Don't you think that we live in a country where the Constitution is supreme, rule of law is supreme, then the matters of property dispute should be decided by the court itself. But the tribunal's decision was final and binding. Many my Muslim brothers calls me from Rajasthan and various parts कि भैया हमारी जमीन में वक्फ में चली गई है, कागज लेकर के जाते हैं और बोर्ड वाले देखते नहीं है. Just irony, understand. So if the Parliament says, look, this law was arbitrary, and that the court of law competent to adjudicate the property dispute must be looked into, where the Waqf which is claiming any ownership over the property has been rightly done, and if not, that should be returned back to the owner who is signing. There was a law, Uday bhai, reason to believe There has to be reason to believe कि सुमित पीर का जो ऑफिस है वो वक्फ का चला गया. Now Sumit Peer won't be having any right to go to the court. He has to go to the board, and the board will go to the tribunal. Tribunal would consist of the similar people of the same majority who would abide by the board decision, and कोई अदालत में दलील नहीं जाएगी. That definitely was need to be changed because 1950. और एक और बात उदय भाई, if देश धर्मनिरपेक्ष है तो कानून भी तो धर्मनिरपेक्ष होना चाहिए. Now another point. सेंटर कैन नॉट मेक एनी.
धर्म से याद आया, अश्विनी डुबे छत्तीसगढ़ के वकील कहते हैं कि वी आर इन फेवर ऑफ द लेजिस्लेशन. द सुप्रीम कोर्ट हैज सेड देयर कुड बी सम हिंदूज हु आर अपोज्ड टू इट एज वेल.
Irony is this only. It's not a Hindu and Muslim. Center has to make a balance between two. If any, because the center cannot be biased for a particular religion. The institution, the state and the judiciary has to go by what the people of the country, irrespective of their religion. That is why we are saying the state can't be religion specific. Political leader one can be religion specific. So I think that the center was being represented to support the bill or the law which was passed by the parliament, क्योंकि states is center की ही duty. Now another point. Unified code for trust and trustee, charities and charitable institution, charitable religious endowment, religious institution and law. But here
देखिए सवाल, देखिए आपको पूरे उस कानून को समझने की जरूरत है. अब 5 साल का मुसलमान प्रैक्टिसिंग रहेगा. 5 साल प्रैक्टिसिंग मुसलमान का तो रहेगा. अब उसको कौन डिसाइड करेगा? अब कोई महिला है उसको कौन डिसाइड करेगा? तो ऐसे कई उसमें जो अमेंडमेंट्स के जरिए लॉ बनाया गया है, हम उसके आज भी मुखालिफत कर रहे हैं और कल भी अपोज करते रहेंगे. और लीगली हम सुप्रीम कोर्ट में चैलेंज किए. हम उसको उन तमाम चीजों को वायलेशन ऑफ द फंडामेंटल राइट्स मानते हैं. थैंक यू.
Ashwini Dubey, of course, continues to be with us. That was Asaduddin Owaisi who was reacting there. Let me also quickly draw in Sanjay Rana, Supreme Court lawyer, who's joining us live. Sanjay Rana, a big interim order, of course, by the Supreme Court. Your quick reaction to what has been dictated by the CJI. Sanjay Rana, can you hear me? Okay, I think we've lost him there. Sumit Peer, let me quickly draw you in here. Sumit Peer, we of course were hearing from Asaduddin Owaisi there. He's also reacted to how the hearing has continued today. Obviously, trying to emphasize who should decide and who shouldn't these contentious Waqf matters. In fact, more reactions coming in. Let's quickly go across to Supreme Court.
भारत सरकार के सॉलिसिटर जनरल है, उन्होंने अपना स्टेटमेंट दिया है कि अगली तारीख तक न तो काउंसिल में न वक्फ बोर्ड में कोई अपॉइंटमेंट जो संशोधित कानून है उसके अनुसार किया जाएगा. दूसरा बात जो माननीय अदालत ने कहा कि जो वक्फ व यूजर है, जो रजिस्टर्ड हैं और गैजेटेड हैं, उसको गवर्नमेंट डी नोटिफाई नहीं करेगी टिल द नेक्स्ट डेट. तो बड़ी इंपॉर्टेंट बात है कि जो रजिस्टर्ड एंड गैजेटेड हैं वही सिर्फ डी नोटिफाई नहीं होंगे, उसके अलावा संशोधन के हिसाब से सरकार कार्रवाई करने को स्वतंत्र है. और जो संशोधित कानून है उस पर किसी भी तरह का अंतरिम आदेश नहीं है. और अगली तारीख तक भारत सरकार को अपना जवाब और उनको जो भी डॉक्यूमेंट्स देने हैं वो देने होंगे. और उसके बाद उनको रिज्वाइंडर का जो पेटिशनर्स है उनको मौका दिया गया है. साथ ही साथ जो स्टेट गवर्नमेंट्स हैं वो भी अपना रिस्पॉन्स देंगे. और ये कहा गया है कि अगली तारीख पर सुनवाई इस पूरे मामले की जारी होगी. तो माननीय सर्वोच्च न्यायालय को जो रेस्पोंडेंट्स यानी कि भारत सरकार ने कहा कि हम डे टू डे सुनवाई के लिए तैयार हैं. आप पूरे मामले को, क्योंकि ये पार्लियामेंट का कानून है, पार्लियामेंट के कानून को आप इस तरह से स्टे नहीं कर सकते हैं. और माननीय सर्वोच्च न्यायालय ने सॉलिसिटर जनरल ऑफ इंडिया के बात को माना है और उन्होंने संशोधन को स्टे नहीं किया है. सिर्फ उन्होंने उनके 2 पॉइंट पे सॉलिसिटर जनरल के बात को रिकॉर्ड पे लेकर के और अगली तारीख 5 मई मुकर्रर कर दिया है और 5 मई से इस मामले की सुनवाई शुरू हो जाएगी.
सर, यथास्थिति की बात कही, यथास्थिति को कैसे लिया जाए?
नहीं, यथास्थिति मैंने आपको बताया कि 2 मुद्दों पर कि जो काउंसिल में और बोर्ड में अपॉइंटमेंट का जो मामला है वो अगली तारीख तक जो स्टेटमेंट सॉलिसिटर जनरल ने दिया है कि कोई अपॉइंटमेंट नहीं होगा. और दूसरा जो है वक्फ व यूजर तो माननीय सर्वोच्च न्यायालय ने अपने आदेश में लिखा है कि जो रजिस्टर्ड हैं और गैजेटेड हैं उसको गवर्नमेंट डी नोटिफाई नहीं करेगी अगले आदेश तक।
सर आप क्लियर है सर, वक्फ भाई यूजर को डी नोटिफाई नहीं करेगी ना, मतलब
नहीं, वक्फ भाई नहीं, सिर्फ वही जो रजिस्टर्ड एंड गैजेटेड हैं।
सर ये कोर्ट
हाँ बिल्कुल, ये ऑर्डर शीट में है। जो रजिस्टर्ड नहीं है, जो गैजेटेड नहीं है, उसको सरकार संशोधन कानून के हिसाब से डी नोटिफाई कर सकती है।
सर आप किसके लिए अपीयर हुए थे?
मैं हिंदू सेना और हिंदू महासभा, दो हमारे एप्लीकेंट्स हैं, उनकी तरफ से मैं संशोधन के समर्थन में हाजिर हुआ।
नाम बता दीजिए, नाम बता दीजिए।
वरुण कुमार सिन्हा, विष्णु गुप्ता के लिए और एक पवन अग्रवाल है उनके लिए, सतीश अग्रवाल। नहीं, आज की सुनवाई पूरी हो गई, अगली तारीख 5 मई की मुकर्रर हुई है। धन्यवाद।
So 5th May, Sumit, is when these hearings will continue, and obviously then there will be proper deliberations once the replies also are filed by the appellates.
Uday, first of all, referring to your last question of Mr. Owaisi, look, Mr. Owaisi is saying, how do you know the Muslim is practicing for 5 years? As per Islam, a non-Muslim cannot donate his property to Muslim or for any Muslim work. It is not considered halal as per the Islam, right? So if you are saying, I'm a non-Muslim and I've donated my property to the waqf, technically as per the rules of Islam, it cannot be done. Now, what was happening, let's say I am a person, I don't have any heirs, I don't have any legal heirs. I have a plot of land. So I'll say when Mr. Sumit Peer passed away, he donated it to the waqf. I have to just produce one small paper. No questions asked. If somebody has problems, he has to go to Waqf Board and Waqf Tribunal, what Ashwani Bhai was right now explaining. And secondly, if you rent a property from me and then one day finally you decide it's Waqf by user, 5 people will get together, says Waqf by user, it will be still handed over to Waqf. Now, what did the government say? Even if if let's say I'm a Hindu, I have converted to Islam, I should at least be there for 5 years. ये तो नहीं मरते मरते कहीं अंगूठा लगवा दिया. I'm on the deathbed, कहीं अंगूठा लगवा दिया, बन गई property. So these are the things which have to be challenged. And I don't know where Mr. Owaisi fails to understand the logic. It is basics. He's a barrister. That is what at least he claims. He should understand these logics. So, coming and finding the nuances of the law is not going to work. What Mr. Owaisi has to reconcile with the fact that amidst his likings and preferences, and let's not forget what his brother said, 15 minutes police hata do dikha denge. That is the mindset which resonates with the family. And after that, he expected that the Honorable Supreme Court will go and overturn the decision and go against what is constitutionally passed by both the houses of the parliament and overturn that to his whims and fancies or to his political likings and to his vote banks. That did not happen. And whatever you are seeing right now, the status quo only for 2 things, what the honorable lawyer was just mentioning on your show, is for these 2 things. You cannot do notification, you cannot do appointments in the board and council, and whatever is gazetted as Waqf by user also for up to 5th of May, that's around 15 days from now, that cannot be changed. That is the only 2 things where it is. So that overturning the case and all is not done. And this is very naive to expect that how did Waqf have so much of land and all that. And Uday, having said that, if parliament passes some law, it's not a question of Hindu and Muslim. There are a lot of Hindu MPs who oppose the law, but how does it matter? It is the question of what the parliament thinks it's right, and who has the majority will pass the laws. You have a right to go to the Supreme Court. You can challenge the nuances of the law. That is okay. But I find it oxymoronic when you are a very learned person and you come up with these small things when you know the logic. You know what the logic is. So the Honorable Court has really done a beautiful job today. They have upheld everything. They have not gone against the Parliament of the India. They have not gone against the Constitution of the India. They have not challenged the elected political members of India. If they would have done that, there will be another fiasco, because that would have sent a precedent that bhai pehle rok do. Anything, first stop it, quash it, then we'll discuss and deliberate it for, let's say, 5 years and we'll come to a conclusion. Now, what the government is also saying, after 5th May, we are ready for a daily hearing, because government knows my case is solid. Our case is solid. It's a matter of time. We'll be able to sail through. That's after 5th May. And let me tell you today, Uday, good news. It is not good news from people like Mr. Owaisi and others. Because if it would have been there for 10, 15, 20 years, at least Rajnaitik rotiya to sikti rehti na, parathe roz bante. But the problem is with daily hearing, it will be concluded very fast. And when it gets concluded very fast, then they have nothing more to talk about. I mean, we have seen people from Kashmir went against 370 to the Supreme Court, and when Supreme Court quashed 370 and Supreme Court said whatever happened is legal and happened as per the law, I have seen Umar Abdullah does not have an NC flag on his table. He has now the Bharat ka janda on his table. So these are the developments which happen. And if some people still believe, I don't want to repeat that, but it's a question that a perpetual Pakistan in making a perpetual Islamic state in making will happen in India. Well, that's not going to happen. That is not how the thing works here. And rules are equal for all. If you're a Muslim, your rules and privileges cannot be more than me. But the Congress's late Manmohan Singh ji said that, and he believed that. That is what the Congress Rajniti is. But the honorable courts have to look at the merits of the case. And Ashwani Bhai made a compelling point. Politicians can be pro-Hindu, pro-Muslim and here, but the state cannot be like that. State, the government or the Bharat Sarkar has to be like that, and the honorable courts are like that. So at the merits of it, it makes a very compelling case. I think what is going to happen is very right. It was a very welcome move. I was really worried that if a stay and all will be granted, then it will be literally in a way infringing into the infringing into the authority or the powers of the Parliament of India, which the honorable courts under the current CJI has rightfully and very tactfully managed this case. So far, we are fair to all. There's no bias, there's no prejudice, and let's wait for 5th May. And I hope that with daily hearing, it is settled soon. And this राजनीतिक रोटी बनाने का जो system है, this bakery, राजनीतिक bakery पे भी ताला जल्दी लग जाएगा. उदय.
Okay. Obviously, for now, of course, the decision, of course, was accepted by the Supreme Court, Manasvi, that the centre will not be appointing any non-Muslims yet. Obviously, something that the petitioners have been seeking, that the appellants have also been seeking, of course, in the court, that non-Muslims should not be appointed to Waqf board and existing Waqf committee should not be denotified till the next hearing date.
Balanced approach from the central leadership also. I think let's be very clear.
Yes, that's a plea that the SG made as well. Yeah.
Work institutions are Islamic religious and charitable bodies. Just as temples and churches are governed by people of respective faiths, it is reasonable and constitutionally protected for Muslims to manage Waqf boards. I think that's a very valid statement by the centre, and this is not exclusion. This is religious autonomy under Article 30, and that is where SG made that statement. And I think I welcome that statement, and that's how harmony in a secular nation, in a democratic nation has to be. You can't appoint someone with no religious or cultural grounding to manage a Waqf property, and that is where the SG is also coming out with that understanding. Yes, there is no bar on audits and oversight. Financial scrutiny is welcome, but not forced communal representation, which I think the government is also not eyeing for that. On the contrary, I think the government is also in support with the Supreme Court, is understanding what the writ petitions are all about, and they are taking a holistic view on this particular issue, and I congratulate everyone on this particular stand. And most importantly, the decision to freeze denotification until the court hears the case is about the status quo and the legal balance, not land grabbing, and this is where the Supreme Court wants to come out and make it very clear, and the centre is also making that statement. I think everyone is online in proper segment in this particular issue. I don't think there is going to be any challenge or any kind of unharmony in our country. I think it's a very balanced and a mature way of fighting a case in the Supreme Court, and the way people are representing. I congratulate all the sides. Yes, there would be political motivation, but leaving that aside, I think it's a very balanced approach for our country to move forward.
All right, we are also being joined now by Sabiha Ahmed, the spokesperson IMPA and member of the UP State Sunni Central Waqf Board. Sabiha Ahmed, the interim order, of course, passed by the Supreme Court today. How do you view it?
I think, of course, very well decided by Supreme Court, and the three things which they have said, like for a non-Muslim member in the Waqf board, or for Waqf by user rules, or maybe a designated officer to decide about the disputes. All 3 points are very valid, and they are definitely by Supreme Court and most welcome. But meanwhile, Vineet, I would like to say, while this process is going on, and as 5th May is approaching, may I request this thing, meanwhile all those Muslim leaders, they should be polite enough, and they should be considerate that what they are going to speak in public and how they are going to address the public, because in this situation the public should cooperate and appreciate the.
Well, I don't know if that's happening, because we have heard reactions from Sadun Owaisi and Manatullah Khan, who were also at court.
the leaders are there, they should give the positive message to public, so that public should not get provoked, they should not be misguided, and there should be positive response from the public. When I say public, I say Muslim. They should wait and watch, and they should appreciate, they must be appreciating what court has said. And but at this time, the Muslim leaders and Muslim scholars and the opposition leaders and political leaders, they should be careful about their words, what they are speaking, because whatever they are speaking, public is listening to it, and they should be careful what they are conveying the message to the public, because what Supreme Court has decided is welcome. Valid points asked to center, and in few days the reply will be there. Everything will be 5th May is not very far, and it's good that things are taking their enough suitable time. It is a welcome step, but these leaders, they should be careful what they are speaking.
Yes. Ashwini Dubey, now what will we expect in the next state of hearing? What can we expect on the 5th of May to transpire once the replies have been filed?
See, if center comes with any suggestions that whether any provisions of the amendment of the Waqf Act shall not be given effect to, as has been done in PNS section 106, where the execution of the death by negligence have been kept in abeyance. If any provision has may come, because as per today's hearing, it was little bit observant that center may come with suggestions. Number 2, court may hear the constitutionality of by framing the substantial question of law, constitutionality of the amendment, whether those are contrary to the constitution, basic structure. And 3rd, court may dismiss the petitions which has been filed challenging the amendment, or may suggest certain things to be amended. Because you see, the courts normally respect the wisdom of the parliament. We have seen in past also that when there was the same-sex marriage hearing was going on before 5-judge bench, and everyone was presuming that the court will pass some orders for legalizing the marriages and also to be registered in the this Special Marriage Act. But since the argument was there that there are certain degree of prohibited relationship have been enacted in the law, and that any judgment passed by the Supreme Court would be violative to the decision taken by the parliamentarians or wisdom of the people. That is what the Supreme Court did not pass any order and given the right to the parliament. 3rd, court may appoint certain eminent people along with the former judge of the Supreme Court to suggest certain changes in the act to suggest. But here we have to see, unless and until the provisions which have been enacted by this amendment is arbitrary and contrary to the constitution, courts normally does not inject inside the decision taken by the parliament, and both the organs of the constitution respect each other. Now, 3rd, one thing may be there, because NJSC case, if you see in NJSC case, Supreme Court 5 judges bench has already quashed the validity of the NJSC Act, and that was completely had gone. But it does not mean that the parliament does not have any power to make the law. We have seen in the case of, you see, the Supreme Court SC Act, when the Supreme Court says that the competent authority first has to look into that whether the case is made out or it is under the vengeance politics or vendetta, this parliament immediately changed that. So those powers lie. So let's see what would happen. But there are, of course, hearing would take place, as took place in the CAA, as took place in the abrogation of Article 370, as took place in the electoral bond, as took place in the case of the demonetization. Number of decisions have been we would, but as of now, 3 things which has been said by the Supreme Court as per the statement of Honorable Learned Solicitor General, that the user properties, Waqf user properties will be denotified until the next date of hearing. No Waqf properties, no appointment will be made, and situation of the ground might change if certain provisions of law are not stayed. So these are the things, let's see. But I think that the Supreme Court would come out with better, proper solution, which would be larger interest. But one point is very worrying for you, me, and all other who respect the law: the violence. Those who are taking cannot be justified in any way, and beating other people, innocent citizens, in the name of the parliament, the amendment is not good. Yes.
Correct.
Jagdambika Pal, Waqf JPC chairperson, is also joining us live. In fact, of course, he's a Lok Sabha member of Parliament of the BJP. Jagdambika Pal, thank you for being with us today. The Supreme Court, of course, passing an interim order regarding the Waqf Act. What is your first reaction to it?
जो बात उठाया गया है सुप्रीम कोर्ट में
जी,
तो हमने इस सवाल पे जेपीसी पे काफी डिस्कशंस हुआ और समय समय पे फैसला हो चुका। 2010 में सुप्रीम कोर्ट में रामराज फाउंडेशन बना, यूनियन ऑफ इंडिया में फैसला हो चुका है कि ये कोई धार्मिक संस्था नहीं है। वक्फ बोर्ड एक कानूनी निकाय है जो वक्फ की प्रॉपर्टी के लिए रखरखाव करता है। 1982 में स्टेट बोर्ड ऑफ कर्नाटका वक्फ वर्सेस नजीर अहमद में उसमें फैसला हो चुका कि ये एक विधि की एग्जीक्यूटिव बॉडी है, स्टैट्यूटरी बॉडी है। तो एक नहीं, कम से कम तमाम सम्मानित उच्च न्यायालयों में सुप्रीम कोर्ट में फैसला हो चुका है कि वक्फ बोर्ड एक केवल एग्जीक्यूटिव एंड स्टैट्यूटरी बॉडी है और वो धार्मिक संस्था नहीं है। इसलिए कहीं किसी की धार्मिक स्वतंत्रता में हस्तक्षेप नहीं है और ये फैसला हो चुका है। इसलिए मुझे लगता है कि सरकार की तरफ से जवाब आएगा तो ये निश्चित हो जाएगा कि इसमें रह सकता है, क्योंकि इसके पहले भी ये सवाल सुप्रीम कोर्ट में उठ।
जी, कैन मुस्लिम्स बी इन द रिलीजियस बोर्ड्स ऑफ अदर रिलीजन्स?
देखिए, स्वाभाविक है कि जो ये स्टेट गवर्नमेंट की बॉडी है और जैसा हमने कहा
जी
कि वक्फ बोर्ड कोई धार्मिक बॉडी नहीं है। धार्मिक बॉडी होगी तो उसमें नहीं हो सकता, लेकिन अगर एग्जीक्यूटिव बॉडी होगी जिसमें प्रशासनिक लोग रहेंगे, स्टैट्यूटरी बॉडी होगी तो उसमें तो रह सकते हैं। इसका फैसला हाई कोर्ट और सुप्रीम कोर्ट हो चुका है। सुप्रीम कोर्ट ने कहा जैसे वक्फ बाय यूजर तो 200 साल पहले हुआ होगा, उसका डीड नहीं हुआ तो कैसे होगा। वक्फ बाय यूजर जो हमने खत्म किया प्रोस्पेक्टिव मैनर में कि अब भविष्य में कोई वक्फ होगा तो उसका डीड होगा और उसको वामसी पोर्टल पे भारत सरकार के अल्पसंख्यक मंत्रालय पे अपलोड करेंगे। ये किया रिट्रोस्पेक्टिव इफेक्ट से नहीं किया। अगर किसी के पास डीड नहीं है, अगर वहाँ पे नमाज होती है, मस्जिद है, खानका है, कब्रिस्तान, इमामबाड़ा है, तो वो रहेगा वक्फ में। तो मुझे लगता है मतलब स्वाभाविक है जब सरकार की तरफ से अटॉर्नी जनरल स्पष्ट करेंगे तो
जी बिल्कुल। नहीं, क्योंकि मुद्दा उठा है इस वजह से मैं आपसे पूछना चाह रहा था ये सवाल। मगर एक और मुद्दा जो उच्च न्यायालय में उठा है पाल साहब, वो ये है कि एक विवाद जो है वो उठा है कलेक्टर के निर्णय पे कि कैन द कलेक्टर टेक द डिसीजन ऑन द वक्फ लैंड। कपिल सिब्बल जो वरिष्ठ वकील हैं इस मामले में भी अपीयर कर रहे हैं अपेलेंट के लिए, उन्होंने कहा है उन्होंने यही मुद्दे को उठाया है उच्च न्यायालय में। आप उनको क्या जवाब देंगे जो वक्तव्य उन्होंने कोर्ट में कल दिया?
मुझे लगता है कि सिब्बल साहब ने पूरा बिल पढ़ा नहीं। अगर कलेक्टर किसी भी डिस्ट्रिक्ट में लैंड रेवेन्यू का ही एक कस्टोडियन ऑफ द लैंड और उसी के पास सारे एक परमानेंट आर्गन है, लेखा जोखा रहता है। लेकिन अगर वक्फ की प्रॉपर्टी में और कहीं गवर्नमेंट की प्रॉपर्टी में किसी प्रॉपर्टी में डिस्प्यूट होगा तो अब कलेक्टर नहीं डिसीजन करेगा। उसका फैसला अब कलेक्टर से ऊपर हमने अमेंड करके कर दिया है कि वो गवर्नमेंट का, स्टेट गवर्नमेंट का सेक्रेटरी लेवल का अफसर होगा, जो डिस्ट्रिक्ट कलेक्टर नहीं होगा या कमिश्नर रैंक का होगा। तो बिल में तो हमने अमेंड कर दिया, सरकार ने अमेंडेड बिल को पास कराया है और अमेंडेड बिल जब पास हुआ है तो स्वाभाविक है कि ये अब सवाल ही नहीं कि कलेक्टर फैसला।
जी जगदम्बिका जी, ममता बनर्जी बीजेपी को दोष दे रही हैं। ये जो हिंसा जो हुआ है मुर्शिदाबाद में वक्फ एक्ट पास होने के पश्चात, ममता बनर्जी का कहना है कि बीजेपी इस हिंसा के पीछे है, बीजेपी जिम्मेदार है। उनका कहना है कि केंद्र गृह मंत्री और बीएसएफ ने ये पूरा प्री प्लान किया। ये जो उन्होंने आरोप लगाया आपकी पार्टी पर और आपके नेता पर, आप क्या कहेंगे, उनको क्या जवाब देंगे?
तो उनकी पुलिस क्या कर रही थी? उनको क्यों नहीं गिरफ्तार कर रही? पिता पुत्र की जो हत्या कर दी गई, जिस तरह से मुर्शिदाबाद में एक वायलेंस घर में घुस करके, तो उनको आज तक क्यों नहीं गिरफ्तार किया जा रहा? और दुकानें लूट ली गई, पूरी पुलिस खड़ी रही। जिस तरह 24 परगना हो, मुर्शिदाबाद, तमाम बड़ी संख्या में हिंदू पलायन करके वो मालदा गए, बोट पे बैठ करके गए। तो आखिर इसके लिए राज्य सरकार जिम्मेदार है। वहाँ तो लॉ एंड ऑर्डर फेलियर हो चुका है। वहाँ पे तो निश्चित तौर से राष्ट्रपति
ममता बनर्जी का एक और बड़ा बयान आया था कल। उन्होंने कुछ मुस्लिम क्लेरिक्स से मुलाकात की थी, इमाम से, मौलानाओं से। नेताजी इंडोर स्टेडियम कलकत्ता में ये मीटिंग जो है वो तब्दील हुई थी। शी सेड दैट योगी आदित्यनाथ, योर सीएम इन यूपी, इज अ हेडोनिस्ट। ये जो वार पलटवार हो रहा है, इस पर आप क्या कहेंगे? इसके आप पर क्या, आपकी क्या प्रतिक्रिया है? खास करके जो बड़ा बयान उन्होंने दोबारा कल दिया है और जो नाम उन्होंने आपके नेता को दिया है, आपके राज्य से मुख्यमंत्री हैं योगी आदित्यनाथ, उनको जो बुलाया गया है ममता बनर्जी द्वारा, क्या कहेंगे?
अब देखिए, ममता बनर्जी कुछ भी कहते हैं। तृणमूल कांग्रेस के लोग जो भाषा कल्याण बनर्जी की हमारे जेपीसी में रहती थी, जिस तरह बोतल फेंकते थे, आज अब योगी जी को देश की जनता तय कर रही है, प्रदेश की जनता तय कर रही है। वो एक पीठ के पीठाधीश्वर हैं और उनके ऊपर इस तरह का चीजें कह रही, तो मुझे लगता है उनको शर्मसार।
ओके, जगदम्बिका पाल, thank you very much for joining us on the broadcast. Chairperson of the JPC, which of course looked into the Waqf bill, and BJP Lok Sabha MP. बहुत बहुत शुक्रिया आपका हमारे संग जुड़ने के लिए। वक्त हो चुका है एक छोटे से ब्रेक का। ब्रेक के लिए हम रुकते हैं। ब्रेक के बाद खबरों का सिलसिला जारी है।
अगर आप बनना चाहते हैं एंकर, या फिर आप में है जुनून एक तेज तर्रार न्यूज रिपोर्टर बनने का, तो आप ज्वाइन करें ITV और इंडिया NewsX का मीडिया स्कूल। ITV नेक्स्ट मीडिया इंटरनेशनल स्कूल का कोर्स आपको मौका देता है देश के दिग्गज एंकर्स के साथ काम करने का। ITV नेक्स्ट मीडिया इंटरनेशनल स्कूल में आप बेहद नजदीकी से देख पाएंगे किस तरह से ITV नेटवर्क के दिग्गज पत्रकारों की टीम दिन रात खबरों पर काम करती है। इस कोर्स के दौरान आप सीखेंगे एंकरिंग की एक एक बारीकी उन एंकर्स के साथ जो देश को रखते हैं हर खबर से बाखबर। ITV नेक्स्ट मीडिया